Yes. Good evening, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important topics, that is anticipatory bail, public auction of natural resources and mining in the leading cases for the upcoming AOR examination. We have the honor to have with us today Senior Advocate Mr. M.R. Shamshad. We welcome you, sir, and we are thankful to you for taking out time.
Thank
We're
you.
showing live on YouTube, and if anybody has any questions, the same may be put in the chat box, and the same will be taken up by sir at the end of the lecture. I now request our secretary to please start with the session.
Thank you, Shamshad sir, for this wonderful lecture. So you can carry on with the lecture because the aspirants are calling me
Right.
to hear you, sir.
I'll just start with a quick introduction about sir. Sir graduated in law from the Campus Law Center, University of Delhi in 2000 and enrolled as an advocate, the statutory body, the Bar Council of Delhi. He's a practicing lawyer largely in the Supreme Court of India. He started practice in 2000 in commercial law in the Delhi High Court. Presently, he practices law in the Supreme Court of India. He's also appeared as a government standing counsel in Supreme Court. Before shifting his practice in the Supreme Court of India, he qualified as an advocate on record from the Supreme Court of India in 2009. In 2024, he was designated as senior advocate by the Supreme Court of India. He's dealt with many cases of vast constitutional importance. His area of law practice includes commercial laws, constitutional law matters relating to religious freedom, rights of minorities to establish and administer educational institutions of their choice, citizenship laws, and elections law, personal laws of religious minorities, etc. He's also dealt with service law and criminal law. He's also written various articles on contemporary legal issues, many published in the leading Indian national daily newspapers. Extensive research on the citizenship laws in India. In the past, he's also delivered lectures in the Indian Law Institute of Delhi and different law colleges in India. I would request you, sir, to please start with your lecture.
Thank you very much. And first of all, I must congratulate the Advocate on Record Bar Association for starting this lecture series for the Advocate on Record examination. I remember in 2009 when we were preparing, only 4 lectures in total that were delivered. And within 1 hour, we were given the entire lecture relating to all the case laws. So congratulations. And Mr. Jain is here, Meenakshi ji, and Aditya is here. So before I start, I would first of all the aspirants who are here, good afternoon to you as well. So to start with, I would first say that all the aspirants must first understand what is the purpose of this case law subject. See, out of these 4 papers, one is professional ethics, second is practice and procedure, third drafting, and fourth case law. See, they all are interrelated. And I consider this case law subject to be extremely important because case laws would give you, first, number one, that what are the basic provisions that can be found in Constitution of India or in the statute books. Number two, from 1950 till date, the Supreme Court of India had occasion to examine, interpret, and understand the ambit and width of those provisions, be it constitutional provisions or the statutory provisions. So once it is placed as subject in your examination, then probably the examiner expects from you, according to my understanding, as following. Number one, whether you are aware of the provisions of law which may be found in Constitution of India, may also be found somewhere in statute books, or it may also be part of common law system. What is common law? That is a separate subject. You can have a look at it. So once these three things are placed before you, then the examiner tries finding from you whether you have understood these three or not, whether you have been able to understand those principles which Supreme Court has laid down. Why? Because once you qualify the AOR exam, then you have to, first thing that you have to do is to interact with the Supreme Court in writing. That will be part of your pleadings, which the judges will read. So they expect minimum basic understanding of those principles. So while you write your answers after reading these judgments, then you must focus that you have largely understood the provisions of law and how the Supreme Court has understood it and how it has been applied in given facts and circumstances. So this is broad thing which I wanted to place before you, which will probably be equally relevant in other three papers. So now coming to the five case laws which I am supposed to deal with right now. First three cases are relatable to bail and arrest. Second is in relation to the natural resources. If natural resources are to be given in public auction, or it is sold to the general public, or through a policy it is given to somebody, what should be the parameter, and what are the guidelines which the court which the government is supposed to follow. And third is in relation to mining of the mines and minerals. So first of all, I would start with the first case. This is Sushila Agarwal. This is 5 judges bench case, which is exclusively relatable to the principles of anticipatory bail. Now, what is anticipatory bail? That is probably not defined anywhere in statute book, but the courts have defined it to say that if you anticipate, for whatever reason, some complaint has been filed, or somebody is preparing to file complaint against you, or if FIR has been registered, or the after registration investigation is going on, if you anticipate that police will come and arrest me, then you go to the court as defined in CRPC, now Samhita, either before the session court or the high court, and invoke this provision and ask for bail, which the court, after considering the entire facts and circumstance and legal provisions, might grant you some protection and may not grant you those protections. Now, what are those principles based upon which the courts give you relief or refuse the relief? So that is the subject matter of this case, which we are supposed to discuss in Sushila Agarwal. So now the case, basically there was a judgment in 1980 which is called Gurbakh Singh Sibia. This was also 5 judges judgment, written by Mr. Justice D.Y. Chandrachud Senior, sorry, Y.V. Chandrachud Senior. So that case had dealt with the broad parameters as to under what are the principles based upon which the anticipatory bail could be considered. If it is granted, then how long this will remain valid bail. So these were the principles, but later on from 1980 till 2018 or so, there were different opinions which came by different benches of the Honorable Supreme Court, in which there were conflicting views. And finally, this matter went to again to the 5 judges bench, in which this judgment was delivered. So now, before this bench, the question was that if anticipatory bail is granted under 438, whether it will be for a fixed period so as to enable a person to surrender and seek regular bail. Question number 2 was whether life of bail under 438 should end at the stage when the accused is summoned in court. What had happened in between, a 3-judge bench had stated that, this anticipatory bail's life has to be for a particular period, which was in a way coming in conflict with the judgment of 1980, which was Sibia case. So after so many judgments, it was considered to refer it to larger bench once again, and the court sat to examine this, and the court examined. And while examining this, there are 2 judgments in this. One written by the main judgment written by Justice S. Ravindra Bhatt, and a shorter judgment is written by Justice Shah. So the principle so emerged, and the larger judgment, which is written by Justice Bhatt, has first discussed about Sibia case to say what were the principles and how divergent opinion started coming in, and how it was not a correct view which were taken by smaller benches. So the Sibia case initially had stated, because all the time when we discuss this, a common perception that we say that when you have to get anticipatory bail, you have to make out a special case for grant of anticipatory bail. There are certain class of cases where you cannot go and ask for anticipatory bail, and court should not consider anticipatory bail. There has to be some presumption attached of innocence. Only in that background anticipatory bail can be granted. So these were the notions which had crept in, which in a way was going against Sibia case. And that's why it needed again a clarification, a reiteration, whether Sibia case principle was correct or it required a different interpretation. And in that background, the court gave its verdict. So the Sibia case, because once you write, once this Sushila principle is to be written or answered, one has to necessarily say what Sibia case was. So Sibia case initially said that, see, the accused is not obliged to make out a special case for grant of anticipatory bail. It is only discretion of the court which has to be exercised judiciously. So this was the principle which emerged out of CBIA case. It further stated that anticipatory bail is not ordinary, but it is not confined to exceptional cases, which generally people talk when we go to apply for a special for anticipatory bail. We start talking that it should be exceptional case. This is not there. This is incorrect. Third thing, that no presumption that accused in particular crime shall abscond. So you can't go with the presumption that the accused will abscond and put the burden upon them to say that, sorry, I am proving that I will not abscond. Fourth, that the court shall exercise their discretion as they do in bail, meaning thereby that the discretion of the court is similar as in regular bail. So there can't be a different parameter for anticipatory bail. Fifth, filing of FIR is not condition precedent for exercising power under 438, because many a times the court may ask that, where is the copy of FIR, and the lawyer will say that it is not registered. So that is not a mandatory requirement that it should be registered. Sixth, bail can be granted after filing, but before arrest. So after arrest, it becomes regular bail. Order of anticipatory bail, this is seventh, cannot be too wide. So this was the background in which the anticipatory bail issue again came back to the Constitution bench for further consideration. Now, when it came here, then they have very heavily relied upon the CBIA principle, and almost all the principles of CBIA has been reiterated and affirmed. That was the reason that I wanted to explain CBIA case in details, so that I need not explain Sushila case once again, because that is the principle that has been taken. So para 53 of this Sushila Agarwal case basically talks about CBIA and how CBIA case has to be largely applied in the anticipatory bail matters. So it said that there is no invariable or inflexible rule that the applicant had to make out a special case, or that the relief was to be limited duration in a point of time, or was unavailable for any particular class of offenses. So the issue that which was referred to Sushila Agarwal case was essentially, obviously the principle was in the background, but the issue was whether this will be for a particular period, or once anticipatory bail is granted, then it will continue till the time court deems it appropriate to modify. So the court finally said that no, CBIA principle is correct. In CBIA also, it was stated that there is nothing to see in 438 which suggests that it is for a particular duration. So there is indication that once bail is granted, till the time it is revoked, it will continue. And this principle has been finally upheld in this and clarified by stating that the protection granted to a person under 438 should not invariably be limited to a fixed period. It should inure in favor of the accused without any restriction on time. So normal conditions under 437(3) and 438(2) should be imposed. And if there is any specific facts or features in regard to any offense, it is open for the court to impose any appropriate condition, etc., etc. So the sum and substance of this case is that once the courts are dealing with the personal liberty of an individual, and there is a statutory provision in CRPC now in Samhita. One important thing that all the aspirants should note, that see, you shall be referring to 438 because all these judgments are relatable to 438. But now the sections have changed. So if you so wish, I don't think that because of not giving reference to new section of Sanhita would make much change. But now since the provision has changed, it has become 482. So if you write this new provision also, then probably that will be an added advantage. And important thing to note is that there in the provision, a new provision, as well as in the old provision, there is no change at all. It is completely the same as it was in 438, now part of 482. So now 482 or earlier 438 is a statutory regulation which ensures personal liberty of a citizen, of an individual who is suspect or could be suspect, or who is an accused before the court. So while dealing with this, the courts are supposed to see overall fact of the case, and the court will exercise its discretion. And if it grants anticipatory bail to the accused, then that bail, until that condition is prescribed in the order itself, that will remain valid till the time the matter goes on or trial goes on before the concerned court. So that is the sum and substance of Sushila Agarwal case. Now coming to if you want, then you can all record para numbers, which is para 65 to 68. This is important for the purpose of what conditions could be imposed by the magistrate while granting anticipatory bail, not magistrate, the court, session court or the high court. And thereafter, para 75, 76, 78 and 84 of this judgment. These paragraphs give you the entire summary of the case, of what I have stated, certainly in a detailed form. So now this is Sushila Agarwal. Now coming to Arnesh Kumar and Satyendra Antil. These are two cases. This is not relatable to anticipatory bail. Arnesh Kumar and later on Satyendra Antil, one can be supplemented with the other. So these two cases are relatable to power of police. Under what circumstances police can arrest somebody? If they have decided to arrest somebody, what are the obligations cast upon police? If the police has arrested somebody without warrant and the accused is produced before the magistrate, what are the obligations of the magistrate at that stage? So these two judgments probably will cover these aspects. So in that background, there are two sections which are very important in the old CRPC. Section 41 and 41A are these two sections which basically regulates the conduct of police and the procedure for the police to undertake while deciding that whether this person needs to be arrested or not to be arrested. So 41 itself has a detailed procedure, and thereafter 41A came, which also sets out the detailed procedure, to which the court has interpreted by stating that at what stage and under what circumstances arrest should be made and where arrest should not be made. It's a very Ernest Kumar is a very short judgment, which points out, if you see para 6 of this judgment, which says that no arrest should be made only because the offense is non-bailable and cognizable. The common perception is that if the offense is non-bailable and cognizable, and the offense is cognizable, then the accused or suspect shall be arrested. So that presumption has been dispelled here. Second, the police before arrest must satisfy that such arrest is necessary to prevent the person from committing any further offense. So this you will find in para 7. So now this is an obligation cast upon the police that, considering the facts and circumstances of that case, the police has to first satisfy itself that arrest is necessary. And this judgment goes on to say that they will record in writing why that arrest is necessary. So next, the police officer is required to issue notice to appear before him After arrest, magistrate is under obligation to examine this procedure and apply mechanical reproduction of the case diary, while authorizing arrest must be discouraged and discontinued. This you can find in para 9 and para 10. Next, authorizing detention without recording reasons by magistrate shall be liable for departmental action by the High Court. Then thereafter certain directions have been issued. So now this is the broad scheme of the judgment. Now, to explain this judgment, while you are writing the paper, one has to first say that why this statutory regime. If there is a statutory regime, then how important it is to comply with those provisions. Now, why this statutory regime? Because this judgment itself says in para 5, 6, and 7 that arrest is a humiliation. It curtails freedom and it casts scars forever. So if an individual who is supposed to remain free in the society, and somebody accuses him for having committed an offense, at that stage, he is only a suspect. He is only a person upon whom certain allegations have been leveled. He is not a convict. He is not a proven criminal. He is only a suspect, and till the time he is a suspect, his dignity, his freedom has to be ensured by the system. So that is the reason the statutory regulatory mechanism were required. And to fulfill those obligations, the state came up with these statutory provisions under CRPC and Samhita. And once it was in place, then it was the court to tell the police that, see, these are fundamental basic obligations cast upon you. Not only police, but also the magistrates, that once this matter reaches you, you must examine the entire case diary, apply your mind, and see that if the police is correct, then you record your own reasons and then authorize further detention or arrest. So that is the basic fundamental of this judgment, Arnesh Kumar. And if there is a violation by the police, then in that case, the consequence is that his entire arrest can be quashed. If the magistrate has wrongly authorized, not followed the principles laid down in Arnesh Kumar, then the high courts are free to take departmental action against him. So that in that way, this judgment is very brings very serious consequence of non-compliance of these provisions. Again, since now this is the first examination after this Samhita came in, this 41 and 41A both have now been merged in one section, and the new section number is 35. There's a very minor change in this, which you can have a look at it. But the scheme of 41, 41A remains the same. So this is what is Arnesh Kumar. Thereafter, the next judgment is Satyendra Antil. Satyendra Antil is again two judges' judgment, in which these issues, these overlapping issues, came again before the court, and the court recorded the fact that there is overcrowding in jail from under trials. In fact, at one place in this judgment, it is recorded that some report has stated that there are 67% under trials who are languishing in jail. So the concern before the court was that the number of under trials inside jail was very, very huge. So it was necessary to see and examine how these arrests are being made, and how police deals with these offenses, because there are some petty offenses also in which arrests are made. So in this background, the judges this judgment emphasizes liberty of citizens, as liberty is essential for the mature civilization. Considering the nature of cognizable offense, evidence to be collected despite offense being cognizable, majority not required to be arrested. So the court is indirectly directly saying that, see, you may have certain evidence, the offense may be cognizable, but there the for making arrest, the reasons have to be different, which I have just stated about with reference to 41 and 41A. So the arrest all the time may not be necessary, and that can be avoided. And in the background of presumption of innocence being facet of Article 21, this becomes further more serious. It also is stated to remind the system that the bail is a rule and jail is exception. Upon registration of FIR, the accused must not be arbitrarily arrested. Enjoying his right of personal liberty, he shall be in a better position to look after his case and defend himself during the trial. So these are basic ingredients of basic fundamental freedom of an individual. And in case some case is registered against him, then to give him fair chance to defend himself, if he remains outside, because till now he's not a convict, he's not sentenced, so he can remain outside, and this will be this will keep him in a better position to look after his case and defend himself in the trial. So that is the basic background of this case. And apart from 41 and 41A, section 60A, section 87, I am referring to the Code of Criminal Procedure, of which 60A new code section is 62. For section 687, new code section is 90. For section 88, new code section is 91. And for section 170, new code section is 190. So these are 6 sections, which the court has analyzed in Satyendra Antil and reached a finding that there are certain circumstances under which bail can be granted in non-bailable offences. Non-bailable warrant should not be issued by magistrate without scrutiny of facts and complete application of mind. He must consider that personal liberty has to be given due consideration. Court should come down heavily on officers affecting arrest without compliance of 41 and 41A, which is now section 35 in New Sanhita. Next, the court said that while courts, magistrates considering summon, warrant, non-bailable warrant, they should meticulously follow the propriety, and non-bailable warrant should be issued only in grave cases. So this is being told again and again repeatedly, that once it comes to the personal liberty of an individual and the case is still at the stage of registration of FIR and the person is still suspect, then the right of the concerned person under Article 21 has to be given primacy, and every mechanism within the system has to very strictly follow the statutory regulations. So with this, the court has again reiterated that Arnesh Kumar principle must be followed strictly, and if it is not followed, then a strict action must be taken against the persons responsible for it. Paragraph 100 is the direction, but there are 7-8 paragraphs in this, which has been devoted for different category of cases, which must be seen before you attempt this question. Paragraph 68, 69, 70, 72 are important. Then again 75, which relates to 77, 78. These are the paragraphs which one must read before writing in detail about this case. So since this is last case, there are provisions which are applicable prior to arrest, in which the individual has to be treated as per statutory norms. But once somebody is arrested, bail has been refused, then once and the person is convicted, so at different stages there are different provisions under which the accused or convict can go and ask for their release. So these are also important, but this is only to reflect that how much emphasis has been given for the release of the person who has been detained by police. So, for example, if somebody has been arrested and he has not been granted bail and charge sheet is not being filed, so there is a provision 167(2) in the old in the CRPC, and new code is 187 clause 2. If somebody is convicted and he has to file an appeal, then there is section 389 in CRPC. Now in new code that continues as section 430. Then there is a section of 436 in Code of Criminal Procedure, where if during the trial, if somebody has already remained in jail for half of the period for which he has been charged, then also he can ask for bail. So these are the provisions which ensures the personal liberty of an individual if he has been alleged to have committed certain crime. So these all three judgments put together reflect at least one fact, that the liberty, freedom of an individual has been given a very high and strong, very, very high regard, so that the individual's liberty is not curtailed, be it prior to registration of FIR, during investigation, during trial, post conviction. For all the stages, there is one or the other provision through which you can knock the door of the court and ask for your release. So Sushila, obviously relatable to personal liberty at one stage, and Arnesh Kumar and Satyendra until at a different stage. All three judgments relate to the larger issue of ensuring personal liberty of an individual. There are subsequent cases in which these guidelines have not been followed, where the Supreme Court has come very heavily and said that these compliances have not been done, and the entire arrests were quashed. One of them is that Prabir Prukastha, 2024, 8 SCC 254. One was Pankaj Bansal, 2024, 7 SCC 576. So these judgments would also reflect the fact that how much emphasis has been given to compliances of the statutory regulations. So now we will go quickly to the remaining two judgments, which are completely different. One is this auction of natural resources. See this, first of all, this judgment 2012-10 SCC page 1 was a presidential reference. Under Article 143 Constitution of India, the President of India had asked for reference, had asked a few questions from the Supreme Court under Supreme Court's advisory jurisdiction, and those questions were in the background of judgment in 2G case, 2G spectrum allocation case. Now, before we attempt to understand this case, 2G case needs a little explanation. What had happened that from 1994 onwards, in 1994 we had one telecom policy. 1999 we had another telecom policy. 1994 was policies emphasized that there has to be affordable telecommunication through which communication has to reach to villages with widest permissible range. 1999, again, similar kind of objectives were there, where it was stated that we need to encourage development of telecommunication in remote, hilly, tribal areas to make affordable and effective communication, etc. So that those policies were going on, and it so happened that at later time, a certain telecommunication spectrums were allocated, and they were not through public auction. So now, since they were not through public auction, the beneficiaries came and got it allotted. Proceeded further. Somebody came to the court and said that these were not done through public auction, and since it was not through public auction, so there was no transparency. There was arbitrary exercise of power. So the court must ensure that it is transparent. Ultimately, it is a public goods. So in that background, one has to see Article 39B. This is part of directive principles, which states that the state shall direct its policy towards securing the ownership and control of material resources of the community are so distributed as best to serve the common good. So this is an obligation cast upon the state that if there is material resource of the community, it must be distributed in such a manner so that it serves the common good in best possible manner. So that is some kind of directives which the state has to follow. So this is the background of the entire case, upon which the case has been filed and the courts have decided. Now, the 2G case had finally declared that all those spectrum allocations were illegal, struck down. So everybody who had got those spectrum, they had to surrender because it was illegal. So that was the background in which the court, the central government decided to ask few questions from the Supreme Court. And the first question that was asked was whether only permissible method for disposal of all natural resources across all the sectors and in all circumstances is by conduct of auction. So that was the question posed to the placed before the Supreme Court to be answered. And second, third were also relatable. But the basic question was that can the central government also try allocating or making a provision for giving some portion of natural resources, considering the larger public interest, where maximization of profit is not the sole criteria. It also serves the public good, public interest. So can the government also adopt different route? So that was the question largely put before the Supreme Court. So before I come to the core answer to this, see, because you have this case law paper, the Supreme Court also has advisory jurisdiction under 143, under which this case was decided. This case, the judgment was given. It is not adjudicatory jurisdiction of the court. It is only advisory. So the opinion was given to the precedent. So the first question in this, first objection in this case, which was posed, was that this reference was not maintainable in view of the fact that the questions are directly conflicting with the judgment given in 2G case, and the judgment in 2G case is under adjudicatory jurisdiction of the Supreme Court, and any advice under the advisory jurisdiction cannot be sought to defeat the judgment given under adjudicatory jurisdiction. So this was one aspect of it on which the court has made some observation after recording the statement of the central government, the Attorney General of India, stating that the central government was not asking any question which is contrary to the judgment. This is recorded in para 38 and answered by the court in para 151 to say that as regards to the question, it says that as regards to the remaining question, we feel that the answer to the question would have a direct bearing on the mode of alienation of spectrum, etc. In the light of Attorney General's statement, the government is not questioning the correctness of 2G case. We respectfully decline to answer those questions, and the presidential reference is accordingly answered. So on the question, on the issue of objection of maintainability against the issue that the reference is being sought directly contrary to 2G judgment, the court has made it clear that there is a statement of Attorney General, and relying upon Kaveri judgment, it has stated that we will not reply to that question. But yes, question 1 to 5 has been answered by the court by giving its own finding to say that it has stated that court cannot suggest the most efficacious method, but the court can test the legality and constitutionality of these methods. Valuation is a function of several dynamics variable. Auction is one of the price discovery mechanism. It is a science, it is not law. So this is para 146, 147, 148. Auction as a mode cannot be conferred a status of constitutional principle. Alienation is an executive prerogative. When not backed by social and welfare purpose, then Article 14, maximizing profit, etc., shall step in. Auction not only permissible method, para 150. So now this judgment examines initial five questions, which is at page 41 of the report. The court says that, we understand that Article 39B of Constitution of India says that it has to serve the best for the common good. But yes, it will depend upon the policy of the government. It will also depend upon the fact that the natural goods are being used for large public interest. It is being used, or it is being used only for gaining profit. So it will all depend upon the circumstances. It will all depend upon the objectives behind it. No straitjacket formula can be laid to say that the natural resources can only be sold through auction. Yes, but when it comes for making profit, or maximizing the profit, then it should be by way of auction. But if it is for certain public welfare, like telecom policy of 99 said that it will encourage the development of telecommunication in remote, hilly, tribal areas, or make affordable and effective communication. So now once the government's intention is to reach out to hilly areas, villages, effective, affordable communication, then certain relaxation will have to be given. And in that relaxation, the auction probably all the time may not be appropriate. So it will be executive discretion, but all the time one thing shall be common, that it has to be transparent, it has to be based on sound principles, and it should serve the stated objectives. It should not be done something else in the garb of doing another thing. So the court finally stated that auction is not the only mode, but all type of such distributions, including auction, will remain open before the court, and the court will examine based upon the principles and circumstances. So this is the sum and substance of this judgment relating to auction of natural resources. There is a supplement. The main judgment is given by Justice D.K. Jain for 4 judges, and this judgment is supplemented by a concurring judgment of Justice Kehar. And Justice Kehar's judgment, para 190, 191, 198, and 199 is also relevant to have a better understanding of the entire auction and distribution process. So this is the 4th judgment. Now 5th judgment is related to mining and environment, and under Common Cause versus Union of India, 2017 9 SCC 499. So again, this relates to the statutory regulations through which the mining is undertaken in our country. So the regulatory mechanism of mining is under the Mines and Minerals Development and Regulation Act of 1957. And there are 2 rules, relevant rules here, which is 1960 rules and 1988 rules. So this is one. And second is principles and guidelines as laid down by the Supreme Court in T.N. Godavarman case. So to understand this judgment, both this act and common principles having developed through the judgment of T.N. Godavarman case is necessary for this. The court says that mining of natural resources is relatable to larger issue of environmental protection, and accordingly, while granting any authorization to undertake mining of different provisions of other regulations also will have to be complied with. Now, what happens in this case, that somebody is given mining lease, and that person would say that, I was given mining lease, so I am free to do mining. And sometime he encroaches the other area which is not covered under the lease. Sometime he doesn't follow the other statutory rules relatable to mining and relatable to larger environmental protection. So the court examines these issues to say that what would be termed as illegal mining. Now, this act in section 21 has some provision of penalty if somebody does illegal mining. So the question was that if somebody has been given mining lease and he does violation of other statutory principles, or he encroaches some other land which is not covered under that lease, whether those violations or those encroachments shall also be treated as illegal mining, so as to fall under the penal provision of section 21. So this is the main issue which was to be considered under this judgment. So to decide this is given by two judges, written by Justice Lokur. The court said that, see, once you undertake mining, which is relatable to very, very larger issue of environmental protection, so you can't say that, see, I have mining lease, I will violate Forest Conservation Act, I will violate Environmental Protection Act, Water Act. So all these provisions are there to ensure safety of the environment. You are doing mining for your benefit, but it can't be done at the intent. The sum and substance of the judgment is that if you are doing mining, you can't say that I will violate all the norms relatable to environment and I will continue doing mining. So the court said that, see, provisions of Forest Conservation Act, Environmental Protection Act, Water Act, etc., shall also have the same value, and the person undertaking mining must comply with these provisions. In addition to that, there is a CEC constituted by the Supreme Court in T and Godavarman case, which was later on notified by the central government. The report of the CEC also becomes relevant, and everything will have to be complied with to say that you have not undertaken, you have not done any illegal mining. So the court said that the issue of illegal mining would include encroachments if you have done some beyond the earmarked area, if you have not adhered to mining plan, which is mining lease, that will also fall under illegal mining, and compliance of the provisions under different legislation, which I have narrated right now, 6-7 legislations. If all of them are complied with, then only one can say that he does not fall under the ambit of section 21(1) and 21(5) to remain out of the clutches of penal provision. So in this background, section 21(1), 21(5) of MMRD Act, because in case somebody contravenes section 4 of the Act, these provisions are penal in nature, and in case any person raises without any lawful authority any mineral from the land, the state government may proceed to recover from such person the raised mineral or the royalty, tax, etc. as per section 21(1). The person can be subjected to punishment of imprisonment, which may be extended to 5 years, and section 4(1) and 4(1)(a) are relatable, and this have to be complied with. For this purpose, you may note down para 129, 130, 142, 143, and 151 will give the a larger picture to understand the scheme of this judgment and obligations cast upon the person who undertakes to mine. There is some background of this case in Goa Foundation case also, of which citation is 2014, volume 6, SCC 590. So, starting from Goa Foundation and coming to this judgment, the provision of illegal mining, the concept of illegal mining can be understood in the background of section 21(5) of Mines and Minerals Act. So this is the last fifth judgment which I was assigned to explain. Thank you very much. Now in one stretch, 5 judgments in one go sometime becomes little heavy, but in any case, not only for the person who is trying to explain, but also for the classroom students who have to understand and take it down. Thank you very much.
Thank you, sir.
Thank you so much, sir, for such an enlightening lecture. There are just 2 questions that I would like to put out. The first question is being asked by Cadret Channel, and he's asked that whether the judgment of Arnesh Kumar versus State and Satyendra Kumar Agdal versus CBI, are these judgments connected to the DK Basu case or not?
See, yes, because see, DK Basu case gave certain directions, and these directions were to ensure the fairness in the process of functioning of police. And based upon those directions, these certain amendments were made in CRPC. And because of that directions, the code that we have today is there. And that code has been interpreted by Arnesh Kumar. So certainly it is relatable. If you start from DK Basu, it will be excellent for the examiner to appreciate your efforts.
The other question is that can you tell the important paragraphs in CBI versus Until judgment?
Okay, so I will I have pointed out, but somehow while stating I could not. Yes, give me that book. I know. Yes, until. Just 1 minute. In fact, I had stated that time. This is para 68 to 72, and then 74, 76, 74 to 78. And then you come to paragraphs 85, 86, and 89. Yes, it's the longest judgment, so there have to be quite a few paragraphs which will have to be read, and then 93.
Right, sir.
Obviously, the concluding paragraph 100.
Thank you so much, sir. And I would now request Aditya Giri, Member Executive, to please give the vote of thanks.
Thanks, Meenakshi. Thank you, Shamshad sir. On behalf of the SCAORA, I, Aditya Giri, Member Executive, would like to express our heartfelt gratitude to Shamshad sir for graciously taking out time out of his busy schedule and attend today's lecture. Sir, your presence and active participation have greatly enriched our discussion and provided valuable insights to all the AOR aspirants. Sir, we deeply appreciate your commitment to our organization and your continued support of our educational initiative through these SCAORA lectures. Sir, your engagement today reflects the collaborative spirit that makes SCAORA a thriving community of learning and professional growth, sir. Thank you once again, Shamshad sir, Nikhil sir, Meenakshi, and all the entire AC for taking out time and contributing to today's lecture. Thank you so much, sir.
Thank you. Thank
Thank
you for
you.
inviting me. Thank you.
Thank you. It is our
Our
pleasure.
pleasure,
Sir.
sir.
Thank you. Sir.